Hello everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you'll enjoy this legal education content. And today will be the day I earn that subscription. For today's story, we are dealing with continuing coverage of the case of Twitter versus Elon Musk. As you know, Elon Musk had proposed to buy Twitter for $44 billion. Now he'd like to not buy Twitter or give them $44 billion. It's very sad. But Twitter would like very much for Elon Musk to give them $44 billion. Thus, we go to court in Delaware, where this corporation is based. Like most corporations, Twitter, and for that matter, Tesla, and all the corporations that Elon Musk created to facilitate this transfer, such as Parent, which is a company that was created basically just for the purpose of facilitating trade. All these companies are based in Delaware. This is no surprise because Delaware is the home to overwhelming majority of companies. I'm not sure what it is, but it's probably like 85% plus. So if you're trying to figure out, hey, which state is a corporation based out of, it's almost certainly Delaware. Delaware has a reputation for being an incredibly pro-business state. It also has a reputation for courts, which as a result of, having 85% of all the corporations based in it are experts in business law. So if you want to have a business lawsuit in any court in the country, well, the Delaware courts are probably the place to be. They are by far and away the subject matter experts. So that's a good thing, I suppose. And it also means as a result that these people, the courts that do this, are well-trained, efficient, and can be very fast. At the moment, perhaps a little too fast, because Elon Musk has filed a motion to slow everything down. He thinks that things are complicated and they need more time. Okay, yeah, I wouldn't be amazed if the court said no, because unlike most states in most issues where cases can go on forever, because Delaware's courts are the courts of chancery where this is being held, because those courts are so experienced on business matters and so subject matter expertise, they can deal with these matters in sometimes months, and often do. So we might have a decision before the end of the year, and whatever that could be. So anyways, let's read this motion for today and see what Elon Musk wants to have happen in the great state of Delaware. This is defendant's motion in opposition to expedite. Twitter would like to have this case happen now. Elon Musk would prefer some other time. Okay. All right. The court should reject plaintiff's Twitter's unjustifiable request to rush this $44 billion merger case to trial in just 2 months. I told you that the courts in Delaware can move fast. 2 months is ridiculous fast for just about any other case in any other court. Like if you came to me today and be like, I want to sue. And like, yeah, 2 months, especially in the last year or so, because, or even more than that, to be honest, because COVID had a effect of backing up the courts incredibly. So it's like, I want this resolved. It's like, well, I hope your schedule in 2024 is looking pretty good because we're not going to court for a while. Well, yeah, Delaware's not like that because these courts basically are the business matter experts. You've got a business case, Delaware's your place to be. At least in terms of judges who know the business law, they're super expert on the issues. All right, so 2 months could be. I mean, it's fast, but then again, stranger things have happened in Delaware courts. Twitter's bid for extreme expedition rests on the false premise the termination date in the merger agreement is October 24th, glossing over the fact that this date is automatically stated if either party files litigation. While filing this complaint, plaintiff has rendered its supposed need for the September trial moot. This is just a stupid argument. This argument is just dumb. And, you really don't want to have a stupid argument in your first paragraph. When you're thinking about things as an attorney, like if you have to have some stupid, which sometimes you do, because sometimes you have, well, for a whole bunch of reasons. Sometimes you have nothing but stupid. And sometimes you have some stupid that you want to kind of bring up, but you want to kind of dismiss. You don't do it in your first paragraph. You kind of hope you bury it somewhere along the way and no one really notices, right? You don't do the stupid right away in your first paragraph. This is pretty dumb, okay? So Twitter's bid rests on the false premise the termination agreement is October 24th. It's October 24th. That is the date in the agreement. Glossing over the fact that the date is automatically stayed if either party files litigation. It may be stayed which is another word for paused, but it's the date in the agreement. It is the date in the agreement. It's paused, but it's the date in the agreement. It's paused until the court makes it unpaused. That's what an automatic stay is, right? It happens automatically by operation of law until the court says not so much. And then Elon says, by filing this complaint, plaintiff has rendered its supposed need for the September trial moot. That is dumb. That's just dumb, right? The date for the merger is October 24th. Twitter would very much like to proceed on that date. That would be their preference, right? Now, if they're going to close on October 24th, we're obviously going to need to have a decision before October 24th, right? If we're going to close on the 24th and we're going to court, if we're going to close, we're going to need a decision by the court on the 24th. So as sort of a natural consequence, when are we going to have the trial? September sounds about right, so that we can have everything we need done so the court can render a decision by October 24th so we can hit our date. Again, the date is automatically stayed, and it will stay stayed until the court changes it. But we'd very much like if the court could operate in such a way to continue to meet our date. So by filing the complaint, plaintiff renders its supposed need moot. that doesn't even make sense. Elon has already said he's not going to perform. This is anticipatory repudiation of a contract. We have anticipatory repudiation. He's already said we're not going to perform. Okay, we'd like you to perform, and we'd also like you to perform on the day of the original contract. So the September date is moot? No. The September date is... no, that just doesn't even make sense. It's such a dumb argument. Nor does the remainder of the motion to expedite remotely justify extreme expedition, instead highlighting the complexity of the case and the impossibility of completing discovery on a timeline proposed. The issues, depending on the issues, might be relatively simple, right? Well, I mean, there's some baseline issues. There's some ways the court could dispose of this thing on a lot of grounds, right? That there's a lot of ways this court could dispose of things, depending on the nature of how they interpret the agreement, right? So one of the things, for example, is Elon entitled to this data? If they can determine the answer is no from the language of the contract, then we don't really need to have discovery, because the discovery would be, well, what is the data? But we've already determined you're not entitled to the data, so we don't need discovery. So if we are able to decide the issue on the papers, then we can do it instantly. That would be what we call a motion for summary judgment. Right? We can decide it instantly. Or if the issues are, if we can constrain the issues, so the issues are constrained, to constrain the issue for trial, it would constrain the discovery. Like, what is the issue? We'll tailor the discovery narrowly. Right? I mean, maybe it can be done, maybe not. Depends on a whole host of things, including injury doesn't occur until failure. That's not how anticipatory repudiation works in contracts. But thank you for your question. I mean, the injury doesn't occur, but this is an anticipatory repudiation, right? They have already indicated that they are not intending to perform. So you can sue for breach of contract based on anticipatory repudiation. If you have an unambiguous statement from one of the parties to the contract that they are not going to perform on the contract, that's an anticipation. That's an anticipatory repudiation. That is sufficient to sue for breach of contract, right? So even though the time is not yet due, this is not a problem. Yeah. So the damages may not have occurred yet, but we know they're certain enough to occur to go to court over it and demand performance. In some sense, perhaps to avoid damage, because if it happens, for the court order, then the damages would be eliminated, which would be great. So yeah, this is not a problem. You can sue for a contract for anticipatory repudiation if you have a sufficiently clear statement from the party of their not performance, and Elon's there, so it's not a problem. But yeah, it's not a problem. Okay. Instead, highlighting the complexity of the case, and the possibility of complete discovery. Depends on the nature of the issues. It depends on the legal issues, and the interpretation of the contract is a matter of law. So, like, what the contract says what its like words say is a matter of law. So the court can determine that without any evidence of any kind because it's just a matter of law. And then depending on what the nature of the dispute is, could eliminate the issues, could eliminate any factual issues or constrain the factual issues, and perhaps we can do discovery that fast. Who knows? It's, not absurd. We might be able to simplify this way down. In fact, Twitter has engaged in a delay tactic for 2 months by resisting defendants' information requests, calling defendants obvious prejudice through an overly compressed schedule. Twitter's sudden request for warp speed after 2 months of foot dragging and obfuscation is the latest tactic to shroud the truth. Well, no. Assuming Twitter has been foot dragging, they're not trying to foot drag now. In fact, they want the court's expedited handling. So they're not trying to foot drag. They want a decision now. So I don't think that quite works. The core dispute over the false and spam accounts is fundamental to Twitter's value. The core dispute is more fundamentally whether or not Elon Musk is entitled to the information he is asking for. It's also extremely fact and expert intensive, requiring substantial time for discovery. Now, if that's not the issue, Twitter is a social media platform whose self-professed key metric is monetizable daily active users. Since the agreement was first signed, new facts have come to light that call into doubt the truthfulness of Twitter's cursory static representation, SEC's filings, that less than 5% of its accounts are false or spam. Yeah, you're going to need a little bit more than like some information to show like basically fraud is basically what you're trying to do. Yeah, that we have some indication the number might be off. Like, you better have one hell of a claim. You better have one hell of a basis to believe it's off enough to matter. So, Okay. On April 28th, just 3 days after signing the agreement, Twitter restated 3 years of its members, despite never disclosing the issue to defense pre-signing. Restated 3 years of its members? I don't even know what that means. Like, they stated again the same number? I mean, it's not a surprise then. Post-signing, defendants promptly sought to understand Twitter's process for identifying false or spam accounts. It might be a little late in the day. It might be a little bit late in the day for that. In May the 6th meeting with Twitter's executive, Musk was flabbergasted to learn just how meager Twitter's process was. Well, one principle of law, by the way, and obviously things get complicated, this ultimately is going to be driven by the contract. But we can talk about principles of law that apply in general. So one of the principles of law is if you buy a thing and you know that you don't know something, then you assume the risk of it. So, like, for example, if I buy, maybe a loot box. If you buy a loot box and you know when you're buying it that there's a certain probability it doesn't contain anything good, then you just assume the risk. Maybe a loot box isn't a great example because you might be involved in gambling. But I'll give you another one. That's a little less gamble-esque. Okay, you buy a car that is advertised as is, and you you buy it with the knowledge that it might have defects that are not disclosed. So, like, you're buying it with that risk. You're taking the risk. You're taking the risk. So if it turns out to have defects that are not known, then that's your problem. So there's examples like that. When you buy something with knowledge that there's an uncertainty, the uncertainty is a risk you bear. So maybe that's the situation here. Human reviewers randomly sampled 100 accounts a day and applied unidentifiable standards to somehow conclude every quarter for nearly 3 years that fewer 5% of users were false or spam. That's it. No automation, no AI, no machine learning. I mean, those might be alternative methods, but there's nothing inherently absurd about using human review. Yeah. John O'Brien, love you, Kurt, but anticipatory repudiation is utterly irrelevant. It presumes full performance by the other side. That's the heart here. But Twitter wants to fully perform. Twitter doesn't want to repudiate. Twitter wants to perform. Maybe I'm missing something, John. And if I'm missing something, I'm happy for the correction. But Twitter wants to perform. Twitter wants to fully perform, don't they? So, and maybe your argument is that Twitter has not fully performed up to date. Maybe that's the argument, right? The idea is that Twitter has not performed on the contract so far. So if Twitter is in breach already of the contract, then you might have a problem. So this does depend on Twitter not being on breach of the contract. That's fair. So if your point is that if Twitter's in breach, then anticipatory repudiation doesn't really work, then you're probably right. This, of course, this requires you them to be in breach, but Twitter says it's not in breach. And so now you're just back to like, well, I mean, Musk says he doesn't want to perform, so there's no doubt about his non-performance. So the only question becomes whether his non-performance is excused, right? We know he's not going to perform. So the only question is whether or not it's excused. In order to determine that, we have to look for legal excuse. But we have enough to go forward on the case to determine that. I mean, it may very well be the case as we get into it. It may very well be the case that we find that Twitter has in fact breached its contract, which means that it's no longer able to sue or no longer able to recover. But we don't know that till we get into it. So I don't think it quite works unless I'm missing something. No. And using human methods as opposed to automation, no AI, or no machine learning isn't like inherently absurd. Alarm, defendants exercise their information rights to validate Twitter user claims. At every turn, however, Twitter deliberately erected artificial roadblocks. The equitable remedy is to unwind the contract. That is an equitable remedy, yes. Unwinding the contract is a potential remedy, yes. Of course, So, I mean, like the remedy to be applied depends on the nature of what's going on. So, yeah, Twitter, so yes. So Elon Musk, John O'Brien is roughly right. Like, we know that Elon Musk is not performing. Elon Musk's non-performance may be legally excused. It may be legally excused because of potentially Twitter's own breaches, right? In the event that Twitter is in breach of contract, then the proper remedy would not be specific performance. We'd be looking to some alternative remedy. This could be to unwind the agreement. This could be some sort of money damages, depending on the nature of breach. Just because both parties are in breach doesn't mean their breaches are equal, or the remedy is simply to unwind. That is a remedy. But there might be money exchanged depending on the nature of things. But yeah, it would be very unlikely to order specific performance if both parties are breaching. That seems like a very odd conclusion. So if you determine that Twitter is in breach of contract, then the remedy of specific performance seems incredibly difficult. You would be looking to other remedies, monetary damages for somebody unwinding the contract. That would make sense. But like, we still know, but the only question at the precise question at the moment we're trying to answer is, can we get to court? And the answer is yes, because we know one side is in breach. We know one side is in breach because Elon Musk is declining to perform. That's an anticipatory repudiation. There's no doubt that he's in breach. His breach may be legally excused, but we don't know that yet. But we have enough to go to court to find out. So, good discussion. Good discussion. Resolving these issues will require complex technical discovery, including forensic review and analysis of large swaths of data. Again, the more fundamental issue here is whether or not he's entitled to the information. The more fundamental issue is whether Twitter's in breach of its agreement, I suppose, on some level. That's really the ultimate fundamental issue, is Twitter in breach, because we know Elon is. Twitter's compliant only adds to the complexity. Rather than... Yeah, thank you, Stephanie. I'm glad that the CF is back. Rather than simply challenging defense termination, Twitter has manufactured a hodgepodge of baseless new claims, none of which were ever noticed. The extensive discovery required for all these claims cannot be complete within 6 weeks. Again, the nature of the discovery that needs to be completed is dependent on the contract. What the contract says is a pure question of law. Interpretation of the contract is a pure question of law. That means it's up to the judge to decide what the contract means. It's not a jury question. Like, once you figure out what the contract means, you can ask the jury, like, whether or not certain things happened. But the underlying aspect of what does the contract say, it's a pure question of law. So it's up to the judge to decide what the contract means as a pure question of law. And so then, depending on the nature of that question, depending on that analysis, we'll then know whether or not there's any material dispute. There may be no material disputes. There are disputes, but none that maybe are material to any legal issue, depending on how the judge interprets the contract. So, but we do know that Elon Musk is not performing, so we know enough to get to where we need to be for the court action. Given the agreement's termination date is automatically stated, it's unnecessary to resolve these weighty considerations on a breakout schedule. Yeah, but we'd like to perform by the original date. So it might not, strictly speaking, be necessary, but it'd be nice. At least from Twitter, it would be nice. Plans proposed schedule would severely prejudice defendants by depriving them of a meaningful opportunity to take discovery, conduct expert analysis, and present their case. The nature of what case they present depends on the legal issues that are in play, which is up to the court. The only relevant date is the outside date for debt financing, April 25th, 2023. Why is that date relevant as opposed to this date? I mean, that date is the state is this date. The request for trial on or after February the 13th, 2023, extremely rapid case before true outside days. Okay, so let's begin with some background history. In early April 2022, Musk began exploring acquisition of Twitter. From the start, he announced his intents to defeat the bots that plagued the platform, degrading the user experience. This argument kind of cuts against Musk because it basically means that he was aware that Twitter had a bot problem. He was buying it to fix the bot problem. This is like buying a distressed house, knowing it's distressed because you want to fix the distressed idea, with an idea of like fixing it up and turning it around maybe. Flip this house style, but Twitter, right? So if you buy a thing knowing it has a defect, then like, yeah. So he's buying it to defeat bots that, according to him, plagued the platform. If you really think they plagued the platform, that doesn't sound like a 5% problem. That sounds like a more than 5% problem, but okay. Although Musk was aware there were bots, he was unaware that Twitter's disclosure regarding them were false. Weren't you, though? If you really thought it was a plague, weren't you? Okay. On April 25th of 2022, defendants and Musk entered into an agreement to purchase Twitter. Rather than engaging in prolonged diligence, pre-signed, defendants bargained for and received representations and warranties regarding the condition and broad information rights. Well, if you gave up your diligence, then you are bound by the contract. So we're back just to what does the contract say? The agreement contained a representation that Twitter's SEC filings, and thus its disclosures, are accurate. Specifically, Twitter represented that none of the company's SEC documents at the time it was filed contained any true statement of material fact or omit facts necessary to make the statements misleading. Musk relied on the representation to sign the deal. Did he? Did he rely on the representation? Again, he, by his own admission, say he's buying Twitter to solve the problem of the plague of the bots. Did he really rely on Twitter's representation that they're only 5% when he says he's buying it to fix the plague of the bots? The agreement also contains an information covenant requiring, this is also, incidentally, by the way, is one of the aspects of fraud. Like, it's not fraud if you detect the fraud. Well, it's attempted fraud, but not fraud, right? So if someone tries to commit fraud on you, but you know it's a fraud, then they haven't committed fraud. Fraud requires you to be deceived. It's attempted fraud, but it's not fraud, right? It's like going to, some used car dealership, and the car dealership is trying to commit a fraud against you. But if you happen to be a person of some sort of sophistication in the industry, I don't know what this would be, a car mechanic or whatever, and you're able to determine the fraud, like it's a fraud, then it's not a problem because you weren't deceived. They tried, but you weren't deceived, so there's no fraud. You weren't lied to because you didn't believe the lie. So, yeah. Shansurian Fraud says, ironically. So if you buy a car knowing the car's shit and buy it anyway. Correct. This is the situation, right? You buy a car knowing it's shit and you buy it anyway. Even if the dealer is actively trying to lie to you about the condition of the car, but you still know, you're there, right? The question is, did you know, right? If you know, you took on that risk. So the fact that the dealer is trying their absolute best to commit the most elaborate fraud of all time, right? If you can see through the fraud, then it's not fraud. So you weren't deceived. So you assumed the risk. Yeah, this is the problem, right? So attempted fraud is criminal, but we're not in a criminal context, right? In order for you to have fraud in a contract, there has to actually be fraud in a contract. Attempted fraud doesn't get you there. Fraud gets you there. Attempted fraud is illegal, but it's not a basis to overturn a contract. Could be fraudulent inducement, not if you didn't believe the fraud. That's the key. That's the whole thing, right? Fraudulent inducement requires you to believe the fraud, right? So fraud comes in two flavors. Fraud comes in two flavors. Fraud in the inducement and fraud in fact. Fraud in fact is where I lie to you about the thing. So I say, okay, it's this, but it's not really that. It's something else, right? I'm lying to you about the thing it is. That's fraud in fact. Fraud in the inducement is not that I'm lying to you about the thing, but I'm lying to you about something in order to trick you into the deal. So I'm accurately representing like what the thing is, but I'm in other sense, I'm fraudulently inducing you into the agreement, right? So the fraud was committed in order to get you to sign on the bottom line is one idea, or the thing in fact was not what it purported to be. So you could have both be frauds or one or the other, right? So you could have fraud in the inducement, but not fraud in fact. You can have fraud in fact, but not fraud in the inducement. You can have both frauds, you can have neither frauds, right? So these are independent. But all these frauds require that you be deceived. All these frauds require that you be deceived. If you are not deceived, it's not fraud. So it's just you assume the risk. If you're able to see through the fraud, it's not fraud. So, yeah. Again, they very well may be guilty of the crime of attempted fraud, but there is no fraud to undercut the contract because you knew and you agreed. So, yeah. You use fraud inducement and fraud in fact synonymously? That's a bad plan. Yeah. If you see through the fraud, there is no fraud. Yeah. Yeah. So if Elon, even assuming that, Twitter over here was lying their ever-loving guts out to the SEC and trying their absolute best to commit all the frauds. If Elon could see through all that, it's not fraud. Twitter might have problems with the SEC for, lying to the federal government, material misrepresentation of facts. They might have problems for the attempted fraud, but if Elon was able to see through all that, then, yeah. Can this go the opposite way? If you sell a car thinking it's broken, but in reality it's fine. Okay. Fraud requires me to know, right? If I'm mistaken, that's an entirely different thing, right? If I'm mistaken about something, it's not fraud. So if I believe what I'm saying, I'm not trying to deceive you, right? Fraud requires me to try to deceive you and for you to be deceived, basically. I have to intend the fraud. I have to intend to trick you, and you have to be tricked. If I'm mistaken, it's not fraud. So if I am selling you something that's not what it purports to be, but I don't know that, it's not fraud, right? I have to know I'm tricking you, and you have to be tricked, right? If I don't know, now we're into a different argument. Now we're into what we call mistake of fact. Mistake of fact. This is different than fraud, right? If I know what I'm saying is a lie, it's fraud. If I don't know what I'm saying is false, it's not a lie, it's not fraud, but it's a mistake of fact. And contract law has things for that too. So if there's mistake of fact, we're in a different argument. Incidentally, mistake of fact applies either way, right? So if I believe something to be true, but it's not, but you didn't, so like if you didn't try to deceive me, right? So again, this could be unilateral mistake or bilateral mistake. Same analysis, right? So like, you don't know what you're saying is wrong, but I do. Or I don't know what you're saying is wrong, but you do, right? Or we both don't know, or neither of us know, right? So mistake of fact can apply both ways, right? So like, if I see, so basically that's where we get into the unilateral, bilateral mistake of fact. Okay, did you know what was being said was wrong? Did I know what was being said was wrong? Did only one of us? Did neither of us, right? And then we're into a different analysis depending on the mistake of fact. Mistake of fact may be a basis to modify or rescind a contract under certain circumstances, but it's still not fraud. It's something different, right? Now we're basically attacking the meeting of the minds idea of contract. The basic principle of contract law is the meeting of the minds with exchange of consideration, right? We both agreed as to what was being exchanged, and we both gave up something in the exchange. We both voluntarily gave up something, and we both were aware of what we and the other person were giving up. That's like your basic contract 101, right? If one of us wasn't giving up something, then there's no consideration, so there's no contract. If we're confused about what we're giving up or mistaken, we have a problem because we had a problem in the meeting of the minds, because what we thought we were agreeing to wasn't really what we were agreeing to, right? The mistake undercuts the agreement, because I thought I was exchanging, this useless rock for $1, but it turns out to be the Hope Diamond. And, somehow I didn't know, and that's a problem. And you didn't know, or maybe you did know, and I didn't know. So, right, that's the kind of thing we're looking for. So if I think it's useless rock for $1, and you think it's useless rock for $1, but it's actually the Hope Diamond, that's what we call bilateral mistake of fact. If I think it's useless rock for $1, but it's the Hope Diamond and you think you're just getting the best deal ever, unilateral mistake of fact. And then we go into the analysis, fun times. I appreciate your questions, by the way. It gives me an opportunity to explain these things. So yeah, fraud requires the lie. Mistake merely requires it to be wrong. It's only a lie if you know it. If you believe it, it's not a lie. Good times. These are good questions. I appreciate them. Okay. Separately, Twitter must use commercially reasonable efforts to run Twitter in the ordinary course of business. Defendants are not obligated to close if defendant has not materially performed the covenants, its representations or warranty are inaccurate and cause an adverse effect. So here, mistake would be fine. Mere inaccuracy might be fine. Is it a test that any reasonable person should know it's fraud? Yes. Yes. The mistake has to be reasonable. Yeah, the mistake has to be reasonable. But, I mean, not everyone knows what the Hope Diamond looks like. So, it might be very reasonable for you not to think it's the Hope Diamond. In fact, if someone's selling you something, and you think it's the Hope Diamond, that would be strange, since you would probably think the Hope Diamond is in a museum somewhere. So you're probably thinking, this is not the Hope Diamond. So if it is the Hope Diamond, well, yeah. So yeah, the mistake has to be reasonable. Yeah. If you're just a complete idiot, then, you know, the law will not save you from your absolute total idiocy and purposeful blindness. The mistake has to be reasonable. And of course, you in fact have to believe it. And for that reason, willful blindness is not a legal defense. Absolutely true. If you purposely blind yourself, you made the decision to blind yourself. So yeah, that doesn't work. Defendants are not obligated to close if the client company has not materially performed the covenants. Okay, we read that. Following a 30-day cure period, defendants might terminate the agreement due to material breach, or if any of the representations or warranties are untrue of closing day, and have or will have a reasonably expected result in a major event. Either party can terminate if the closing does not occur by October 24th, but that date automatically extends during litigation. That would be the nature of the stay, yes. The debt financing supporting the deal has an outside termination of April 25th, 2023. Okay. Just 3 days after defendants signed the agreement, Twitter restated. I misunderstood what they meant by restated. They changed them. I was like, why is restating it a problem? What you mean is changed then. Okay. I misunderstood what you mean by restated. All right, fine. Just 3 days after the defense signed the agreement, Twitter restated its figures. In other words, they changed the figures, disclosing it had been double counting users since the first quarter of 2019. Oh, okay. By restating its financials, Twitter's effectively made the changes are material and portrayals or estimates as precise. Okay. Well, it would turn into why they reached that determination when they did. Like, if they somehow just determine that now, like, everything goes to, like, what's commercially reasonable, basically. Right? If everyone's exercising the commercial reasonably due diligence and, like, Twitter's making the best representations they can, and it just so happens to be that 3 days afterwards they realized, oopsies, we made a mistake, like, well, you know, that's just the normal course of business. If they purposely withheld that information, that is, you know, purposeful withholdment, which is looking more fraudulent now, isn't it? Defendant promptly sought to validate Twitter's user-based representations. Thus, on May the 6th, Musk met with Twitter's leadership, including its CEO and CFO, discuss, among other things, how Twitter calculates its spam population. Musk was stunned to discover Twitter's process for identifying spam accounts relied on human reviewers to eyeball a minuscule portion of the user base rather than using the company's machine learning capabilities. I mean, machine learning is great and all, but it can only do so much, and human beings in the process isn't the worst idea I've ever heard of. Musk quickly understood that management did not have a handle on the bot and spam issue. Yeah, but are you just reaching that realization now? This is the problem. You made a whole bunch of statements in advance of Twitter has a bot problem, I'm going to fix it. It's a little bit hard to say, oh, I'm just realizing now there's a bot problem. I was mistaken / tricked. Were you mistaken / tricked? Twitter information covenant breaches. In a series of formal follow-up requests starting on May the 9th, defendants requested numerous categories of information regarding user-based issues, including access to the Twitter fire hose. One diligence request couldn't be plainer. How do you estimate that fewer than 5% of the accounts are false or spam? Another request made clear that Mr. Musk also sought to verify Twitter's key metric independently. In response, Twitter has led defendant on a 2-month treasure hunt of delays, technical bottlenecks, evasive answers, and ultimately refusals. Yeah. For example, on June the 15th, Twitter provided defendants with something it misleadingly labeled the Twitter Firehose Internal, which the media has widely reported was Twitter's firehose, but it was not in fact the firehose. Instead, defendant received a bespoke partial data set structured to make the necessary machine analysis impossible. When you say structured to make, do you mean that Twitter purposely made the structure impossible to analyze? Are you saying that Twitter, because Twitter is not obligated to make the data in a better form for you. Like, at best, they're required to provide information that they already have in the form that they would already use it in their ordinary course of business. If that form is inconvenient for you, but it's what they normally would do, then sucks to be you. If instead you're trying to say that Twitter deliberately changed the structure to make it difficult for you, then that's a different problem. Yeah. Defendant attempted to navigate those roadblocks with requests from Morgan Stanley beginning 9th and sent follow-up letters on the 25th and 31st and June 6th. And before concluding that Twitter was intentionally withholding requested information. It might be requested, but was it required, and was it even really, strictly speaking, necessary? Because maybe Elon waived the issue long ago. Twitter admitted its much, writing to defendants that if you finally provide the existing firehose steam, the data would be insufficient to perform the spam analysis defendants sought to conduct because Twitter still refused to provide the private data required. Well, what do you mean refused to provide? Do you think that Twitter had it and wasn't giving it to you, or did they have to change the data in some way, which they are not obligated to do? The partial information that Twitter did provide only heightened defendants' concerns. In its SEC disclosures, Twitter listed the daily users, first among its key metrics, tying it as a leading measure of the company's performance, including its much-hyped goal of delivering 315 million data users by the fourth quarter of 2023. Average daily users is defined as people, organizations, other accounts who logged in or otherwise authenticate and access Twitter on any given day. Twitter also represents that not more than 5% of these accounts in any quarter consist of false or spam accounts and claims to remove them from the account. There are a lot of very, very qualified words in there, which there is a limit to how qualified we're going to let you get away with. You can't qualify yourself out of, you can't just, if the number is really 50% and you know it, you can't write 5% with a bunch of qualifications. All the qualifications in the world are not going to get you from 5 to 50%. But if the number is really 8% or even 10%, then a lot of qualifications will help. So yeah. The daily users is critical according to Twitter because it bears directly on their prospective value, I would think. As Twitter noted on Analysis Day, without an audience, there's no revenue. Thus, if Twitter's actual thing is materially less than represented, not only has Twitter made misrepresentation that may justify rescission, but it's also likely to reduce Twitter's value, which could constitute a major event. Well, yeah, maybe. Twitter adopted, in its covenants, Twitter adopted saying that the SEC filings were accurate. The SEC filings were qualified to hell. So, your ability to rely on them, we're going to interpret 5% with a lot of flexibility. I mean, that's just yeah. And also, did you really believe that 5% was the correct number? Man. Since the deal was signed, Twitter has adopted significant personal changes that violate its ordinary course obligations. That doesn't necessarily violate ordinary course. By instituting a hiring freeze that extend to existing officers, filing the company's revenue product lead and head of product, and terminating a third of a talent acquisition team. Contrary to what the complaint implies, Twitter did not give notice or request consent. I mean, that might be ordinary course of business. There has been a bit of a downturn in the market. Following Twitter's persistent disregard of its contractual obligations, on June the 8th, they terminated the agreement. Until then, defendant had met all their obligations, devoting substantial resources to pursuing the transaction, including financing. On June the 12th, Twitter sued defendants, challenging not only their termination, but introducing blunderbuss. I love that. That's cool. Blunderbuss claims regarding defendants' supposed breach of their obligation to close, consummate financing, provide information, consent to operational changes, refrain from disparagement, and preserve confidentiality, most of which are premature and all of which are reckless. There is no automatic right to expedition. Of course there's not. That's dumb. It's a request. If you didn't, yeah, of course there's no automatic right. The standards for expedition must be considered against the backdrop of the burden imposed, the court and the public, when the court orders the party to litigate on an expedited schedule. Planned schedule is unnecessary and unduly burdensome. Twitter's unjustified bid for expedited trial must be rejected. Twitter premises its request on the supposed drop-dead date of the agreement. It is the date the thing is supposed to occur. We'd like it to occur. But observes that such a date is automatically extended. Yes, it is automatically extended, but we'd like it resolved if possible. That would be nice. We'd like to continue with the date, if we can. Specifically, if any suit is bought for specific performance, the termination date automatically extends to either 20 business days following the action's adjudication or as the court establishes. So, yeah. Thus, the only relevant date by which litigation must conclude is the debt expiration date. Must, maybe, but again, we'd like it to finish if we can. Twitter is they have a perfectly reasonable basis to ask. And the court has a perfectly reasonable basis to say no. If it wants, depending on the nature of the issues, it may not be able to be done in the time frame. This is a $44 billion merger. You want to do discovery in 2 months. That's, yeah, I couldn't do that in a simple case. Discovery in 2 months, I don't think so. In a $44 billion merger, no, my first thought is no. How do you like no? But depending on the nature of the issues to be litigated, if any, then maybe, yeah. While Twitter has proposed a trial within 60 days, this court has observed it would be extraordinarily fast to try a complex busted deal case within even 5 to 6 months. Twitter's request to compress the schedule at a fraction of the time is impossible. maybe this deal is less complex. It might be worth more. That doesn't mean it's more complex. Indeed, the case goes well beyond the significant complexities of the typical deal, implicating complex data science questions concerning the accuracy of the disclosures. The factual record regarding these representations will likely involve sifting through hundreds of billions of actions on Twitter and reviewing related samplings and control process. Just the time it will take to load, process, and analyze hundreds of terabytes of relevant data will exceed the schedule. Depending on what we need to try to resolve, yes, possibly. Additional discovery is required regarding all 4 of defendants' bases for termination, as well as makeshift collection of 6 meritless breach claims first introduced in a complaint. Well, that would be the appropriate time to introduce them. Defendant anticipate these issues will require at least 30 to 40 fact depositions and at least 12 expert dispositions in total. If we're going to get into the issue of whether the number is accurate, maybe. But maybe that's not the issue. These include fact depositions of principals and advisors that negotiate the merger, top management, board members, data science, and audit personnel familiar with Twitter spam and false account detection procedures, financing and advertising executives, and executives knowledgeable of Twitter's operational changes. It also required the 30B6 deposition of witnesses who can explain Twitter's information system and processing for identifying spam and false accounts, as well as its process controls for governing Twitter's disclosures. Yeah, you want to make this a really open thing. Okay. Completing this amount of discovery by September is unworkable, let alone having trial that same month. Yeah, if that's the discovery we have to do, that is definitely unworkable. That cannot be done. Instead, holding the trial in February 2023, which also is pretty impressive, to be honest, would balance the interests of the parties and the court by allowing sufficient time for a merits judgment and appeal before that expires. You think the appellate court's awfully fast, don't you? Nearly every case Twitter cites to support its lightning speed schedule either involves genuine drop-dead dates or stipulated trial date. Okay. Finally, while plaintiff cites the uncertainty surrounding Twitter's ownership and market conditions as a basis for the hyper-expedition, this is a truism in all busted deals. Probably. As plaintiff acknowledged, the termination date provides an indication of how long the parties intend to be in contractual limbo of the operating subject to interim covenants. Hereby including a provision automatically extending termination date through litigation, the parties express their intent to ensure sufficient time to adjudicate disputes. Okay. Given the April 25th outside date for financing, this case should proceed on a pace akin to some other cases. Extreme expedition is also one warranted because any exigency stems from plaintiff's strategic delay. Unclean hands? Let's give it a shot. Defendant first requested information regarding the data on May the 9th. Had Twitter either promptly complied with its obligation or informed defendants it would not, this dispute could have ripened in early May. Plaintiffs attempted to impose the burdens of if they had said they're not going to comply, then we would have had a breach. Plaintiff attempted to impose the burdens of expedited proceedings on the defendant, and the court cannot reconcile with his failure to proceed with the case. Accordingly, this court should adopt the defendant's subject. Well, the issue is the proper interpretation of the contract. I mean, that's the immediate issue for the court. What is the proper interpretation of the contract, which is a pure issue of law? So what does it mean? And then what disputes, if any, remain? So, but I think in the end of the day, there's a pretty good argument I think there's a pretty decent argument on Elon Musk's own tweets before the deal regarding the bots and the BART problem and all the rest of it. I think there's a pretty good basically assumption of risk provision. He knew there was a problem. We really think that he relied on the 5% number to his detriment? We think there's an equitable issue where he relied on to his detriment, or that he was fraudulently induced by those numbers, which I don't think he can't be fraudulently induced by the numbers because I don't think he saw the SEC numbers before the agreement. He only said he saw him afterwards, right? Or is he saying he saw him before? Either way, I'm not sure that there's fraud. So, yeah. Is there a difference between the letter of the contract and spirit of the contract? Yeah, there's a big difference. What's the spirit of a contract? What's the spirit of a contract? Yeah, the contract is going to be defined by its letter, particularly in this case, where you have two ultra sophisticated parties. So this agreement is going to be very determined by the contract and not much else. I wonder if lying to the SEC is protected under 230. It is not. No. Lying to the SEC is most decidedly not protected by Section 230. No. Also, Section 230 does not apply to criminal acts, and lying to the federal government is a crime. So Section 230 doesn't apply because they're the ones making the statements. It also doesn't apply because it doesn't apply to crimes, and it also doesn't apply because there are some crimes. Based on your experience, if you had a hazard guess, which side are you thinking has the better argument? Based on what's going on right now, I think Twitter has the better end of the argument. The problem is Elon Musk's own statement. Like at the end analysis, right? At the end analysis, the problem is Elon Musk's statements about the bot problem. It's really hard to say, oh, I was tricked into this because Twitter says only 5% of its things are bots, and it said that to the SEC, and I relied on that. I was tricked. I was fraudulently induced. It wasn't what I thought I was buying, which is another way of saying fraud in fact. I relied on to my detriment, equitable argument. I was tricked. I was misled. I was mistaken. Were you? Because there do seem to be a suspicious number of statements, which you yourself mentioned, by the way, in your own pleading, that you knew there was a bot problem. You were buying Twitter to fix the bot problem. I totes thought that Twitter had less than 5% bots. Doesn't quite jive with your statements. It seems like you knew there was a problem. So I'm having a tough time with, I was tricked into it because I thought the bot number was 5%. It's not what I thought it is because it's 5%, not 5%. Or I thought it was 5% to my detriment. Yeah, I'm not sure you believed any of that. So that's the biggest problem. And so if you are interpreting a provision of a contract that says something like, I'm entitled to any information reasonably necessary for any reasonable business purpose, then verifying the bots is not a reasonable business purpose because it is not a element of the thing that you're buying, at least as far as you're concerned. Because you're like, well, the bot problem's really big, so why do I need Twitter to give me information to prove the bot problem is really bad when I basically thought that going into it? It doesn't quite work. It would work a lot better without the statements from Elon. So Elon's tweets may very well be the end of him. So these might be the most expensive tweets in the history of time. Because if Twitter's not giving information, even if they're doing it deliberately, they're not really in breach. Because the information can, even if Twitter doesn't know that, they're not really in breach. Twitter might even think they're breaching, but they're not. This is done without the contract. We have the contract. We're protecting provisions we don't have. Where are the exhibits? We don't have any exhibits in at the moment. We don't need it because at the moment we're just on pleadings. But we have a contract. The contract is 60 pages long. But the issue is even if Twitter thought it was like breaching by not providing the information is irrelevant because it goes to something that Elon assumed the risk for. So even if they thought they were breaching, they're not in breach because Elon was never entitled to win in the first place. So, yeah. Yeah. So, like, if, you know, in the absence, so if the bot issue is dead, then you have a problem. Because what else is there? They didn't operate themselves in the ordinary course of business by instituting hiring freezes and all the rest of it. There was a market downturn. That seems like a prudential business reason. That they were running themselves in the ordinary course of business. You know, when you buy it, you assume the risk that the value is going to go down or up, for that matter. You hope it's going to go up, but you know, yeah. Relied on the SEC filing? I'm not sure he did. That's the problem. I'm not sure he did rely on the SEC filing. His reliance would have to come before the point he signed the contract. That's the only way it makes any sense. And he had tweeted before he signed the contract that Twitter had a massive bot problem, and he was going to solve the massive bot problem. So how could he possibly have relied on statements from the... How could he possibly have relied on Twitter statements to the SEC that Twitter had less than 5% bots? And also tweeted at the same time, I'm buying Twitter to fix the massive bot problem. So you say he relied on it. I'm like, how? His own statements seem to suggest very strongly he didn't. Twitter needs to prove good faith. Good faith in what? Good faith and fair dealings in the contracts in general? There's a general provision of good faith and fair dealing. That's true. But if Twitter wasn't breaking the contract, then why should his statements matter? All that should matter is what's in the contract, because it goes to what he thought he was buying, right? The idea, why should his statements matter? The statements matter because we're not trying to interpret a provision in the contract. You can't use oral statements to supplement a contract or contradict a contract. That's the parole evidence rule, right? So if you're trying to interpret a contract, you're interpreting it for the parole evidence rule. But like his own statements matter as to, well, first of all, the contract can't speak to fraud and the inducement. That doesn't even begin to make sense because fraud and the inducement is necessarily outside the contract. So if you're trying to prove fraud and inducement, I was tricked into the contract. If you're trying to prove I'm tricked into the contract can't speak to that issue. And even if the contract says I was not tricked, like, no, like that doesn't, no, that there's problems with that. You can't really do that. So his statements are relevant to fraud in the inducement. They're also relevant to fraud in fact, because the contract says I was buying a Twitter. In this context, the Twitter is a healthy Twitter that has a bot problem that's under control. The SEC statements reflect that it has a statement under control. So it's a good Twitter. But if he's assuming the risk of it, then like it goes to what he thought he was buying. He can't complain that he bought a lemon if he thought he bought a lemon, or accept the risk of buying a lemon, right? It's like, it doesn't quite work. So that's why his statements matter. Do I honestly think specific performance is a disfavored remedy in law, unless you're dealing with real estate. If you're dealing with a piece of real property, like I want the land, then specific performance is much more common. It's very common in real estate. Outside of real estate, it's unheard of. Well, unheard of is strong. It's very disfavored. But apparently in Delaware, they will issue it, or they're willing to issue it. So I think specific performance is a possibility if Twitter complied with the contract. If Elon went into this thing with both eyes open, I don't see the Court of Appeals saving, I apologize, I don't see the Court of Chancery saving his ass. If he knew, then he was buying a Twitter. Let's point more to the point. If he thought he was buying a Twitter that had a massive bot problem, and in fact, he's buying a Twitter that has a massive bot problem, he got exactly what he thought he was buying. So, or if he bought the Twitter with knowledge that the nature of the bot problem was unknown, but he knew it was unknown, then yeah. You have not talked about the break clause. Does not provide the buyer the right to exercise that option under some limited circumstances. Yes, there's some limited circumstances under the break clause, but none seem immediately relevant here. Could Elon say the big bot problem was the number of tweets from the bots, but still believe less than 5% of the user base was bots? That seems... Understating customer base by 5% to come to an agreement is materially different. Then you find out you don't really know how overstated the number of customers is. He did no meeting of the minds as to what was buying. If he thought that, well, that is the answer is in the premise of your question. Like, Brenda, the answer is in the premise of your question. You say understanding customer base to 5% to come to an agreement is materially different. Yeah, the premise is in your question. It's understanding the customer base to be 5%. That's the key, right? What was his understanding? What was his belief? That's the key, right? If he understood the customer base to be 5% and it's not, then we have a whole bunch of arguments. If he didn't understand the customer base to be 5%, because he knew that Twitter's bots were completely out of control, and or he knew that like the nature of the problem was unknown, then he didn't understand it to be 5%. He understood something else. So his understanding is a very key element of this entire thing. The price is based on public data. Could he offer a price based on unproven inferences, then sue that they don't accept his offer? He can offer a price based on anything he wants, as long as it's not inside information, right? If he wants to, you can speculate all you want for price, right? I mean, the price of anything is presumably based on publicly available information. But if you have some reason to think the publicly available information is wrong, sure, you can speculate a price that is not in conformity to the public information. But then again, you kind of know you're doing that, right? So if everyone is kind of saying collectively this item is worth $100, and you're like, well, I have reasons to believe it's worth the market is undervaluing this, it's really worth $150, then you're fine. Like, you're not basing it on inside information. And for that matter, you're not really basing it on public information. You just think the public has come to the wrong price point, which it does sometimes. So you are gambling that there's going to be a correction in your favor in the future. But you're making that choice, right? You're choosing to believe that the public at large has come to the wrong number. So, like, the value of anything is basically what someone will pay for it. At the end of the day, like we all learned that in basic economics, right? The value of anything is what someone will pay for it. So if the public at large is valuing Twitter at one number, but he thinks for whatever reasons that number is wrong, he thinks the public is wrong collectively about the price, then, he's allowed to make an independent assessment, independent of the market. He can think the public is wrong too high, or he can think it's wrong too low, right? And then that's basically stock trading 101, incidentally. Like, oh, I think the public is wrong about the price. I think it's too high / too low, so I'm going to buy / sell, as the case may be, right? To steer into where I think the market's going to be into the future, because I think the market's wrong. So like, yeah, so you can absolutely make an offer based on things outside of the public knowledge. As long as it's not inside knowledge, you're fine. John O'Brien says, you do realize I'm the same guy with you on mic earlier this evening. I do. Trying to support you, but you're kind of condescending. I'm not trying to be condescending, John. I'm trying to answer your questions as best as I can. I apologize if I'm coming off as condescending. I'm not trying to be condescending. I'm trying to answer your questions. I know how you feel, though. Fuck me. I'm doing my best. I really am. I'm sorry if it's coming up. I'm trying to answer. I'm not trying to be condescending. I'm trying to answer your questions. The questions are very legitimate. I'm trying to answer your questions to the best of my knowledge and the best of my understanding. And I'm trying to explain it. I'm not trying to be condescending. I don't understand the problem. You're fine? Apparently I'm not fine. Apparently I'm not fine because, I mean, I can see where you say, I know how you feel. So apparently I'm coming off as condescending. Apparently I'm failing. I'm trying to answer these questions in good faith. I might be wrong. I'm doing my best to answer them to the best of my knowledge and understanding. Any possible connection between pursuing Twitter's purchase and Musk's relevance in depth heard? I mean, anything's possible. It just doesn't strike me as immediately obvious. No, I appreciate John's opinion. I respect John. And I respect Stephanie. I respect their opinions. Because they're people I trust. So if they think I'm being condescending, then I just need to try harder. I just need to try harder and not be condescending. You think I'm answering the questions in an autistic way, Shashurian fraud? I don't even know what that means. I'm playing devil's advocate and that's your personality? I'm not intending to play devil's advocate either. I'm just giving my honest best answers to the questions that are currently pending based on my current knowledge. These are tough questions. I'm just answering the question. I'm not intending to play devil's advocate. If I thought, I always try to assess every single case based on what I think the answer is at any given moment. You guys know that. If I think that if I think Amber Heard is right, I'll tell you. If I think Johnny Depp is right, I'll tell you. If I think Elon Musk is right, I'll tell you. If I think Twitter's right, I'll tell you. I'm always trying to honestly assess every single case as honestly as I can based on my knowledge of the understanding of the facts and the law as they then exist. And then as I gain more information, my opinion sometimes changes. It's kind of what you hope. You would hope that one's opinion would change as you gain more understanding. So if I gain more understanding of the law, if I gain more understanding of the facts, I'm like, oh, okay, I made a mistake. I need to correct for that. But that being the case, I'm not now, at this moment, trying to devil's advocate. I'm just trying to assess the situation. I'm trying to answer the questions, right? So I'm trying to look through this as logically as I can to assess it, right? So here's the logic flow of the entire thing, right? Just kind of break it down, right? So here's basically the outline of the argument as it currently exists, as I basically understand it. All right. We have Elon Musk has breached. This is undeniable. His breach, in order to get past that, we're going to have to find some sort of legal excuse for him, right? You can't just breach on a contract for the hell of it. So Elon Musk is absolutely in breach because he's announced he's not going to perform. So we need to find something that Twitter's doing to be in breach. This is ideal. This is what Elon Musk wants, right? Elon Musk is only right if we can find a reason that Twitter's also in breach. If Twitter is also in breach, then it seems impossible to get specific performance. If they're both in breach, then we're looking at some other remedy. That remedy might be a whole bunch of things. It might be unwinding the contract and putting everyone back where they started. It might be some sort of monetary damages to one side or the other based on the nature of the breach. Just because both sides are breaching doesn't mean their breaches are equal, right? But so it might be an assignment of money, like in something, might be some sort, like, so there's some sort of remedy, maybe, but we're not into specific performance. And that's the thing we're trying to avoid right now, specific performance, if we're Elon Musk. Right? The thing we're trying to avoid right now is being forced to buy Twitter. Like, whether or not we have to pay money is not our immediate problem. So let's focus on our immediate problem. We'd like to not have to buy Twitter very much. In order to do that, we have to show a breach by Twitter. Okay, so what have we pointed to as a potential breach by Twitter? Well, we've pointed to, in the filings, we've pointed to the contract, which has two provisions which are on point. We've said that Twitter has made certain representations. These representations include that their SEC filings are accurate. Okay, that's the number one thing. That's one. Twitter says, one, our SEC filings are accurate. Okay. Two, Twitter says we will provide we'll provide all reasonable information reasonably necessary towards the consummation of the deal. We will provide all relevant information. So we've got two things. Our statements to the SEC are accurate. We'll provide all relevant information towards consummation of the deal. Great. Twitter, Elon comes back and says, hey, problem. It appears that your representations to the SEC are not accurate after all. It appears that this 5% number is a complete made-up fiction. He has said, at least publicly, it might be 4 or 5 or 10 times as much is what he said, right? This 5% number is way off, right? We're not talking about a modest deviation or even a kind of quasi-important distinction, because there's so much qualifying language in the SEC disclosure that the number is definitely not 5%. It's 5% plus or minus some margin. What the margin is open to debate, but there's a lot of qualifying statements. That being the case, if we're talking about 4 or 5 or 10 times as much, it's hard to believe the margin is covering that. So if the number's really 10% or even 15%, like, the statements are probably open enough to allow for that, right? That's not material. That's probably not a falsehood to the SEC, right? We need these numbers to be way off to make this work, okay? So Elon Musk says the numbers are in fact way off. They're 4 or 5 or 10 times as much. They're way off, okay? And he also says, look, partially in suspicion of this, I've asked for a whole bunch of information so I can independently validate this. And, like, I want to validate this covenant. One of the covenants you have is that your SEC's filing is true. And I want to find out if that's correct, because now I have suspicions. So I want to find out if it's true. So I need information so I can find out, and you're not giving me the information. So you're in breach for not giving me the information so I can verify what you said is true, is in fact true. Okay, that's the argument that's going this far. So I have identified a potential problem to this logic flow. The potential problem to this logic flow is that Elon Musk knew the number was wrong. He believed the number was wrong. He didn't think it was 5%. He believed it was more than 5%. He didn't believe 5%. He thought the number was a lot. Subjectively, he thought the number was a lot. Okay. There are statements from Elon Musk to support this contention. Elon Musk has made tweets that basically seem to strongly say, if not outright, just flat out say, that Twitter has a massive bot problem. I am buying Twitter to fix the massive bot problem. These seem to be the thrust of several of Elon Musk's statements and tweets before purchasing it. Elon Musk is saying, Twitter has a massive bot problem. I am aware of the massive bot problem. I am buying Twitter to fix the massive bot problem. This sounds a lot like Elon Musk believes there's a massive bot problem. If Elon Musk subjectively believes before buying it there's a massive bot problem, then the SEC statements are kind of irrelevant, because he doesn't believe them. So it's not fraud, right? He knows or believes in his own head, he believes the number's wrong. So when Twitter says, hey, we are guaranteeing the number's 5%, Elon Musk is thinking to himself, subjectively, yeah, right. No, it's not. But if he's thinking that, he's not being fooled. He's not being tricked. Like, Twitter might be trying to trick him. Twitter might be hoping to pull the wool over his eyes and be like, hey, 5% Elon? But if Elon is subjectively in his own head saying, 5%, that's full of shit, then he's not being tricked. So it can't be fraud in the inducement because he's not being tricked. There is no fraud. They might be trying to commit fraud, but he's not being tricked. So there's no fraud. So it can't be fraud in the inducement. So there's no fraud in the inducement. So now we're moving into the contract. Right? It wasn't that I was tricked into the contract. I wasn't tricked by that 5% number because I wasn't tricked. So there's no trick. So now we're into the contract. Twitter says in part of the contract, hey, our Twitter is a good Twitter. It's part of the warranties we're giving, incidentally. Like, we are warranting this information. We are warranting that our Twitter is a good Twitter. If Elon Musk knows their Twitter sucks, then the representation is meaningless. It's not fraud because he's not tricked, right? This would be the rough equivalent to, I don't know, a con man. I don't know. What would be a con man scheme that would make sense in this sentence? This would be the equivalent of a con man offering me, I don't know. Let's go with a white van speaker scam, old school. Okay, white van speaker scam, old school. All right. I come upon a white van that is selling speakers out of the back of a van. This used to be a common scam, right? Common enough for it to get a name out of it. And this guy says, hey, these are the top-notch speakers. These are the best speakers. I am a repo guy. I am a construction guy. I am whatever. And I've acquired these speakers. And, man, these are just the best lines. I pulled them out of a club this morning that defaulted on a loan. And, you know, these speakers are worth $20,000. But I have no particular need for them. So for you, my friend, special price. Right? For you, my friend, special price. Instead of $20,000, how about $10,000, right? Well, if you are a random guy and purchasing these speakers, you might very well be tricked by this story. That would be the nature of the con, right? Oh, these are really, really good speakers. These are $20,000 speakers. Boy, geez, am I getting a deal? Lucky me, right? Now, you might be a little bit foolish, but you're being tricked. That's the nature of the fraud. That's the nature of the scam, right? That's the nature of the scam. But what if you're not that guy? What if you are a sophisticated speaker enthusiast? All right, you're a sophisticated speaker enthusiast. Man, you are you love the speakers. Man, your audiophile setup is second to none. You write audiophile reviews. You do the speaker reviews. You in fact, you installed most of the speakers in most of the clubs in the city because you are just the best sound technician ever, and everyone just loves your work. You are the guy. Okay, and you show up, and the white van is there, and white van guy says, "Hey, I've got these speakers. These are the best speakers ever. I pulled them out of a club. You're worth $20,000." And you're thinking to yourself, "Wait a second, no, you didn't, because I'm the best speaker guy ever. I know you're full of shit, right? These are not the best speakers ever. These speakers are worth like $2. These two speakers are worth $2 in trading stamps." These dollars are worth about $3.50. And you want me to buy them for $10,000, you're out of your mind. But instead, for whatever your own reasons are, right? For whatever your own reasons are, even though you know all that, you say, you know what? I'll buy those speakers for $10,000. Right? So, okay, well, that was a dumb thing to do because you know the speakers are not worth $20,000 or even $10,000. You know they're worth $3. But for some reason, that, is known only to you and God, you have decided to buy these speakers for $10,000. Well, you can't turn around and say, I was defrauded. Because you weren't. You weren't tricked. You knew exactly what you were buying. They committed fraud on you two ways, by the way, in this story, right? They made up a whole story about them, a club shutting down and everything, which is total bullshit. So fraud and the inducement, right? They made up a story about how they came into the speakers. It's from a repo job that I just did. And, I came into these speakers and, look at these. And I have to dispose of these because I have nowhere to put them. I'm not a speaker guy. I'm just a simple contractor. I have nowhere to put them. So I need to get rid of them. So, I need to get rid of them right now. Blah, 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 right? The entire story is a fantasy, fraud and the inducement. I'm in fact selling you speakers that are not what they purport to be, fraud in fact. But I know that they're not what they purport to be, thus no fraud, right? And because I install all the speakers in basically all the clubs, I know that you didn't get the speakers from a club because I know basically every club, and I know that you didn't buy them from a club because I know that. There's no club in the world that uses those speakers. Or at least in town, because I installed them all, right? So your story about where you got them from didn't trick me because I know better. Your story about what they are didn't trick me because I know better. Despite all this, for reasons known only to me and God, I decided to buy the speakers. That's on me. There's no mistake and there's no fraud. I'm not mistaken because I know exactly what they are. I'm not fraudulently induced, or I'm not committed fraud against because I know what they are. So there's no fraud, there's no mistake. The contract is valid. The contract is valid as to me because I know better. All right? That's what we're talking about. So we move to our situation with Elon Musk. And Twitter says, oh, geez, all these statements are totally valid from the SEC. 5%, don't you know? Hey, 5%. The entire market has been pricing Twitter based on this 5% representation. That's the price, and it's really worth that, right? So, hey, the entire market's apparently being tricked. But the question is Elon Musk being tricked? That's the relevant question. And the evidence appears to suggest no, he's not being tricked. The entire rest of the market might be being tricked. The entire price valuation currently being assigned to Twitter might be wrong. But he knows better. Everyone else might think Theranos collectively is worth $5 billion. That's the market valuation of Theranos, or it was at one time. Right? The entire market thinks that Theranos is worth $5 billion. It's really worth nothing, but the market doesn't know that. Right? But if you know that, not from inside information, mind you, not from inside information, but just because you have the requisite knowledge to determine, right, then you're not tricked. There's no fraud as to you. There might be fraud to the entire rest of the world, but not to you. Right? This is why the facts matter. This is why you have to do an individualized analysis. So if you view Elon Musk's statements that he made on Twitter and on other mediums before the contract, if you view the statements he made of Twitter is a bot infested company. There are so many bots. I am buying Twitter to fix the bot problem because there are so many bots. They are full of the bots. I am buying it to fix the bot problem so Twitter can become a bot profitable company. If you view those statements and those gists as him saying, hey, the 5% number is not the real number, then what are we talking about? There's no trick. There's no mistake. There's no fraud. He bought Twitter knowing exactly what he was doing, or at least he was actively aware of the uncertainty of what the issue was. He knew there was an issue with the bot thing. He might not know exactly what it is. But he knows there's an issue. If he knows there's an issue, if he knows there's an uncertainty, At the time he buys it, there is no fraud. There is no mistake. He knew exactly what he was doing. And he will be bound to his agreement. Right? That's the analysis as it exists right now. So, I mean, that's what we're talking about. Now, you can disagree with that, but that's sort of where my analysis is driving right now, and my explanation for it, right? You could say the statements aren't that clear, they aren't enough. There's a lot of things that you could say, but if everything is kind of like what I just said, then that's the right analysis. So, you know, it's like, so I don't mean to be condescending. I'm sorry if I'm sorry to John, and I'm sorry to Stephanie, I'm sorry to anyone else if I come off as condescending. I'm not trying to be condescending. I'm just trying to explain it. And like, I'm not trying to be like, well, actually, or I'm not trying to be like, well, that's silly, or I'm not trying to be like whatever. I'm just trying to express my opinion as best as I can. Here is my opinion as to the issues that are currently in play. Here is my conclusions at this time as to what seems to be Elon Musk's weakest point of the problem. And if I'm right, it's game over, because nothing matters, right? Nothing matters, right? Twitter's covenants are irrelevant because he knew they were wrong, so they don't matter. Twitter's promise to provide information is irrelevant because the information couldn't have helped him, because he knew it was wrong. He didn't need the information to tell him it was wrong. He knew it was wrong before he ever got the information. The failure of Twitter to provide him information is irrelevant because the information, according to him, would have told him what he already thought was true. So Twitter can provide the information or not, and his belief doesn't move. So it doesn't matter. It's irrelevant. It's not a material breach because it can't impact the value of the contract. It's a meaningless provision of the contract. The breach is meaningless because the breach does nothing to impact Elon Musk's value because he knew exactly what he was doing. And Jerry says I'm doubling down on being condescending. Again, I don't know. I'm not trying to be condescending. I'm just trying to walk through the issues and be like, here's the issue. Let me explain it. Explain it by analogy. Explain it by reason. If you go to a used car dealership and you buy a used car and the car dealership says, best car ever, totally mechanically reliable. If you're a car newbie, that's one thing. If you're a car expert mechanic and you know instantly it's not true, it's an entirely different universe, my friend. Because you know exactly what's happening. There's no fraud and there's no mistake. So if you buy the car anyway, well, what are you complaining about? You got exactly what you thought you got, exactly the price you thought you were getting it for. So what's the problem? So that's the answer. So I don't know if I can do any better than that. And the problem is that Elon himself is saying it in his own documents. This document is submitted by Elon. This is Elon's document. See, it says right at the bottom, attorneys for Elon. This is Elon's document. Elon is writing this. So what does Elon say is true? Right? What he says is true. It's a party admission. So what does he say is true? Like, okay, let's go over what he says is true. Let's see. There's something in here. Look at this. Look at this. This is Elon himself talking. In early April 2022, Musk began exploring an acquisition of Twitter. From the start, he announced his intention to defeat the bots that plagued the performance, defeating the user experience. Although Musk was aware of the bots, he was unaware the disclosures regarding the users was false. But were you? If you knew the bots were wrong, if you knew the bots, then you knew the disclosure was wrong. So you're just lying. From the start, he announced his intention to defeat the bots that plagued the platform. Elon Musk says, from the very beginning, the very start, the moment I conceived of the idea of buying Twitter, from square zero, I knew I was doing it to defeat the bots that plague Twitter, but I was totes confused, misled, and defrauded by the 5% number. You see how these two thoughts don't quite jive in the same universe? I mean, it's like it just doesn't work. It doesn't work. So the whole thing falls apart. Like his entire cause of action falls apart in one sentence. His entire cause of action falls apart in one sentence. From the start, from the very beginning, he announced his intent to defeat the bots that plagued the platform, degrading the user experience. Sounds to me like Elon Musk knew the bots were a problem, and a massive one at that, at square zero. So you tell me, was he tricked, deceived, misled, didn't know what he was buying? When he knew from the very start, the beginning, his intent to defeat the bots that plagued the platform, you tell me. I mean, that's an admission. It's in his filing. It's an admission. It's a party opponent's admission. Statement against interests. So, I'm not speculating, by the way. I'm not speculating that Elon knew. Elon just told me that he knew. He just told me he knew. So what do you want me to do with this information except say, well, that's a real problem for Elon? That's a real problem for Elon. Jerry says you have to know you're being condescending now in a humorous way. I give up. I tried. Well, I tried. I hope some of you found some value in this anyway. I did my best. If you've enjoyed this stream, please remember to like, comment, subscribe. I hope that you got some value out of it, despite whatever my shortcomings are. I'll be on later. Until later, my friends, I hope all is well. Cheers, my friends, and goodbye.